Hello. Are you the member in Ontario of a Municipal Accessibility Advisory Committee for some municipality in Ontario? Or are you the member of a Special Education Advisory Committee of a school board in Ontario? If so, this video is for you. My name is David Lepofsky. I'm the chair of the Accessibility for Ontarians with Disabilities Act Alliance, or AODA Alliance. I've also got a background in the work of both of these kinds of committees. I've spoken to many of them, been called upon to give input and ideas to many of them. I also led the campaign from 1994 to 2005 to get the Accessibility for Ontarians with Disabilities Act, or AODA, enacted. It's the law that now creates municipal accessibility advisory committees. And as for the work of special education advisory committees, well, since 2015, I've been a member of the Special Education Advisory Committee, or SEAC, of Ontario, indeed Canada's largest school board, the Toronto District School Board. And for 2 years, 2016 and 2017, I was also the chair of that SEAC. One more thing I'll tell you about me. From 2018 to 2022, I was appointed by the Ontario government as a member of the provincial Kindergarten to Grade 12 Education Standards Development Committee. There's a long title. It is mandated or it was mandated to make recommendations to the province on what we need to do to make Ontario's school system fully accessible to and inclusive of students with all kinds of disabilities. So pile that all together, and this is a very familiar topic for me. What I'd like to talk to you about over the next few minutes is whether you're a member of a Municipal Accessibility Advisory Committee, AAC, or a Special Education Advisory Committee, SEAC, or both. What can you do, and what should you do to have the most impact on inclusion and accessibility for people with disabilities? Most people serving on these committees don't have any background in the whole law governing all of this, and so I want to give you some practical tips to bring you right up to speed so you can have the biggest impact you can. When I talk about disabilities, I'm including all kinds of disabilities: physical disabilities, mental disabilities, sensory disabilities, intellectual disabilities, mental health conditions, neurological disabilities, everything. When I talk about accessibility or barriers, I mean all kinds of barriers: built environment barriers, those physical barriers to the built environment, technology barriers, bureaucratic barriers, all of that stuff. So let's let's get right to work here, and I'm going to tell you that as I discuss this, uh, everything I'm going to talk about is going to apply pretty much to all of your work, whichever kind of committee you're on. There's a few points where I'm going to focus specifically on one, but not the other. But I'll make it clear at that point when we're at one of those situations. So, where do these committees come from, these AACs or CACs? Well, they're required by law to be created. In the case of a municipal AAC, they were first required by law to be created in 2001 by a law called the Ontarians with Disabilities Act. It's since been repealed. It's been replaced by the AODA, or Accessibility for Ontarians with Disabilities Act. And if you want to look it up, it's section 29. It tells you everything about what you can do and who can be on your committee and so on. And in the case, and every municipality with at least 10,000 people on it has to have an AAC. Every municipality with less than 10,000 has the choice. It can have one if it wants, but it doesn't have to. Now, as for SEAC, Special Education Advisory Committees, they are created by a regulation under the Education Act. And for those who want to look it up, go look it up. It's Ontario Regulation 464 of 97. 464/97. And it says who can be on it, what you can do, and so on. Now, it's important to understand that these are provincial laws. So municipalities cannot adopt rules that conflict with them. School boards cannot adopt rules that conflict with them. So if you're on one of these bodies and some staff member from the city or the staff says, oh, well, we have a bylaw or we have a rule here that you can't do so and so. If that conflicts with either the AODA for Municipal Accessibility Advisory Committees or the regulations under the Education Act, well, those provincial laws prevail. And that's really important. Now, what is your power? What can you do? Well, you can't make any decisions or give any orders for anybody to do anything. You can't make anybody do anything. You are, in both cases, an advisory committee. Your power is to give advice. In the case of an accessibility advisory committee, to the municipality. In the case of a special education advisory committee, it's to the school board. You can give advice or, put it formally, make recommendations. You want to advocate for change and improvements, and the best way to do it is to put your advice into a formal motion that your committee passes that sets out a specific recommendation. Now, there's two ways of doing it. I mean, one is a formal motion, which says we recommend that, and so on. But another way is just to sort of informally at a meeting of your advisory committee, just to give advice, just offer your thoughts. But that's not a bad thing to do, but the problem is that alone doesn't have as much oomph. The strongest impact you'll have is not when it's just one member sort of saying, hey, here's what I think you should do, but when you get a majority of the committee to vote for a motion, and a motion that includes a recommendation. Now, there's no fancy way that these have to be written. Some people put a bunch of whereas this and whereas that at the start. You don't have to. You could just make a recommendation. Our committee recommends that, and then it can list specific recommendations. More about how to do that in a second. But what you really want to do in your recommendation, in a motion that you get passed, is to identify a particular barrier or problem facing some or all people with disabilities, and then recommend a specific action that you want the municipality or the school board to take to fix it. Now, why put it in a formal motion? It's for a couple of reasons. First, once you do that, it is then should be transmitted by the city staff, in the case of an AAC, to the city council members, or in the case of a school board, to the elected school trustees. And then they have that advice in formal terms, and it starts, in my mind, a clock running. It starts a process where you can say as a committee, hey, we've given you this advice. What have you done about it? Now, they aren't required to answer it, act on it, implement it, but if you take some of the other steps I'm going to talk about in a few minutes, you can ramp up pressure to try to get things done as a result of your motion. Put another way, what the recommendation does when you put it in a formal motion and it's passed by your AAC or your SEAC is it puts the city or the school board on formal notice of a problem and the need to fix it. So when you're writing one of these, what should you do? Well, my suggestion, if you want to put some preamble or whereas clauses, you say whereas, and then say there's a problem, what it is, and then say we recommend that. So I'll give you an example. At the Toronto District School Board, we have a problem, and I think it's probably common across the province, that a lot of parents of students with disabilities don't know what's available, what options and supports there are for their kids at school that are disability related. So we passed a motion when I was chair about 7 years ago, and it said, I'm summarizing, that parents of students with special education needs often find it difficult to find out what options are available for their child at school. We therefore recommend that, and then we offered specific steps of actions we wanted to take. I suggest don't make it too argumentative, don't use loaded language, just make it matter of fact and recommend specific action so that people can look at it, whether it's staff in the city or the school board or elected politicians, and can ask themselves, hey, does this make sense? Does that problem exist? What should we do about it? Now, how do you go about doing this? Do you just walk in one day and offer a motion and hope everybody will pass it? There's a few steps I'm going to suggest. The first is I think it's a really good idea if you want to raise an issue to be addressed at your Special Education Advisory Committee or your Accessibility Advisory Committee to let the committee know in advance you want to raise the issue. If it's about school board not letting parents of students with special education needs know about what's available for their children at school, an email to the members of your committee and to staff saying, I'm concerned about this. Could we put it on the agenda? And here's a really important staff point. Can we ask staff to report to us on what's being done so far? What are you doing about this issue? How are you handling it now? And in the case of our Toronto District School Board Special Education Advisory Committee back in 2016, we asked the school board, what do you do to educate parents or to inform parents of what's available for their children at school that's disability related, and how do you access it? And we got a briefing from school board staff. And they basically said, we basically leave it to each principal to explain it. Our committee thought, well, that's not good enough. There should be more systematic information available. So after you get the staff feedback or staff briefing, then have a discussion with your members of your committee and see how people feel about it. If there's a recommendation that you think would get a consensus of support. You only need a majority, but heck, the more that support it, the better. Then what you can do between meetings is try writing up a motion, just a draft motion. And you can circulate it by email to your fellow committee members and say, hey, folks, what do you think of this? And on email, this is really helpful to do this between meetings because with email, people can pipe up and say, I think that's a great idea. Or they might say, that's not a very good idea. Or why don't you change it this way? And if you can, through back and forth, you can reach a point where by the time you get to a committee, and if you get the chair of the committee to put it on the agenda, hopefully people can have a discussion, make sure everybody is comfortable with it, or a majority are, and then you pass it. It's really important to make sure you talk to staff of the city or the school board first, because look, if you pass a motion, what's going to happen is it'll go to the city council or the school board trustees, and they're going to ask the staff what they have to say about it. So you might as well hear first. Now, what can a motion do? What can a formal recommendation do? Well, there's several things. It could lead the city staff, if you're on an AAC or the school board staff, to look at it and go, hey, this is a good idea. Let's do it. And it may never have to go to the trustees or the elected city councilors for a vote or a decision. It may be a matter of simply you make the recommendation, the staff come back and say, we think that's a great idea and we're working on it, and here's what we're going to do. That is a way to create change. It may be that you've got the staff of the city or of the school board. Maybe they actually think what you're raising is a good idea, but they can't get enough support within the municipality or the school board's bureaucracy. So your motion may help create pressure that helps them get something accomplished that they'd actually like to do. Now, on the other hand, it may be that the bureaucracy at the city or at the school board, they're not prepared to act, at which point you, by communicating your motion to the elected politicians that are on city council or on the school board, they might, if you're successful, look at it and go, well, maybe the staff don't want to do this, but we think we should. And then they can make a decision and direct staff to do it. Now, either way, this is a motion helps establish a public statement. Now, stick with me, and in a few minutes, I'm going to give you some practical tips on how to get one of these motions once you make it to be as effective as you can, recognizing that there's no guarantee they're going to listen to you. Now, let me take a step back. Before I give you a bunch of other practical tips, I want to spend a couple of minutes on what school boards or municipalities are required to do for people with disabilities. There are several pieces of legislation that govern this. The Accessibility for Ontarians with Disabilities Act, or AODA, requires every municipality to become accessible to people with disabilities by 2025. Unfortunately, we're way behind. It also requires every school board to become accessible to students with disabilities by 2025. Again, we're way behind. There are a number of regulations called accessibility standards that have been enacted under the AODA, which impose specific requirements. But the AODA is not the only game in town. There are also two other really important laws. The Ontario Human Rights Code, in Section 1, guarantees the right to equal treatment without discrimination because of a disability in access to goods and services and facilities. Well, when it comes to school boards, education is a service. When it comes to municipalities, lots of the things that municipalities do for the public are services and facilities. They must ensure equality for people with disabilities in access to them. Similarly, our Constitution, the Canadian Charter of Rights and Freedoms, is part of our Constitution. In Section 15, it guarantees to every individual the right to equality before and under the law, and to the equal protection and equal benefit of the law without discrimination because of a physical or mental disability. That is the supreme law of Canada. Both the Human Rights Code and the Charter of Rights include, as part of the guarantee of equality, a right on the part of people with disabilities to have their disability-related needs accommodated up to the point of undue hardship. Now, I don't have time here to give you a full explanation of what the duty to accommodate people with disabilities means, but I've got a separate video up on YouTube, captioned and available to you, and I encourage you to watch it, where I give you an introduction to the duty to accommodate people with disabilities. But your recommendations that you can make if you're on an AAC or on a SEAC can often be an attempt to get the municipality or the school board to live up to their obligations under the AODA, under the Human Rights Code, under the Charter of Rights, under the duty to accommodate. I encourage you to watch that video. I'll have a link to it with the YouTube posting for this video. I'll also have a link to an introduction to the AODA, AODA 101, to give you basic ideas. And I'll also give you a link to a video I've done which offers tips for parents of students with disabilities on how to advocate for your child at school. But those are the important laws that prevail. And by the way, moment of information for SEAC members. When you're on a SEAC, you will hear a lot of talk about special education under the Education Act. Special education is available for students with special education needs. They use this unfortunate and troubling term, students with exceptionalities. But those don't cover all disabilities. There are some disabilities protected by the Charter of Rights, protected by the Human Rights Code, that our special education laws don't cover. That doesn't let school boards off the hook. They are obliged, under the Human Rights Code, under the Charter, under the AODA, to serve and provide equal rights to students with all kinds of disabilities. And that prevails over any weaker law. Now, let me turn now to the question, what can you give advice on? Let me talk first about, in general, then I'm going to talk a little bit about AACs, and then I'm going to talk a little bit about SEACs. Generally, you can give advice on anything you want to give that pertains to people with disabilities. So without getting worried about any of the complex stuff that you might want to get addressed, just if you've got an issue, if there's a barrier, if it's impeding people with disabilities in some way, feel free to pipe up about it. The worst that'll happen is they won't listen, but in any event, you can cover anything. Uh, since if you think about it, the Human Rights Code and the Charter of Rights covers the whole spectrum. Now, beyond that general thing, accessibility advisory committees of a municipality, there are specific things you can give advice on. Under the AODA, municipalities and frankly, school boards as well have to have a 5-year accessibility plan. And you can and should be consulted on that and give input. Not just being told after the fact, here's what our plan is, hope you like it, but being able to see it when it's being developed and give input on what should be included. Uh, Similarly, every year the municipality or the school board has to do a report, a progress or status report. You should be consulted on that. And if you're not, if the staff don't come to you, you should go to them and say, we want to give you input on this. As well, just turning to municipalities for a minute, you can ask to give input into site plans that are submitted to the municipality for approval. Okay, this is a big topic. I'm just going to give you a few headlines. Sometimes when a company or an organization wants to develop a piece of land, they have to submit a site plan for approval by the municipality. You can, under the AODA, under Section 29, ask, if you're a Municipal Accessibility Advisory Committee, to see the site plans and to ask to have input into what accessibility requirements the city should insist upon. Now, you might think to yourself, I don't know how to do that. Well, you can call on the city to have some of their planning staff or their legal staff explain to you what's involved, and then you can offer your ideas. Again, the city doesn't have to listen to you. Doesn't have to do. They have to listen to what you say. They don't have to act on what you recommend. As well, under the AODA, the city is required to seek your input on the accessibility of new buildings or major renovations of buildings that the city is either purchasing or renovating for the city itself. Similarly, the city or the municipality is required to consult you on accessible design criteria to be considered in the construction or renovation or replacement of bus stops or shelters. You know, it's great when buses, city buses, are accessible, but if where they let you off is not accessible, it's not of much use to you. Under the AODA and standards enacted under it, the city municipality is required to consult with you with their accessibility advisory committee on the proportion of accessible taxi cabs that the community should require there to be on the road. As well, there are a series of requirements for consulting the Accessibility Advisory Committee on outdoor parking, on-street parking, recreation trails, and so on. You should ask the city to provide for you a list of what you are required to be consulted on and ask them when they're going to consult, how they're going to, and make sure that they do that. Now, let me turn to special education advisory committees. When it comes to municipal accessibility advisory committees, the city appoints the committee, and a majority must be people with disabilities. Special education advisory committees can include representatives of incorporated parents associations, such as an association of parents of children with a particular special education need. As well, they can appoint community representatives, that is to say, not part of any organization. And in the case of both AACs and CX, they can have elected politicians. In the case of AACs, city council members, and in the case of CX, elected school trustees. The regulation that governs special education advisory committees lets you give advice on anything regarding special education, from your perspective, I'm going to suggest to you it's anything regarding education of students with special education needs. Those are students with who are gifted or have certain named disabilities, but you should include students with any kind of disabilities. Um, don't feel yourself limited to only students who have conditions that the law defines with this troubling term exceptionality. Um, uh, Now, the school board, apart in the case of CX, there's a couple of things they are required to consult you on. Every year, the school board is required to come up with a special education plan. You're required to be consulted on that. As well, you're required to be consulted on the special education budget. Now, this is really important. This doesn't mean that they can come to you, they just need to come to you after the fact and say, oh, here's the budget we passed. Hope you like it, and do you have any questions? They are required to consult you on what the budget should say, not after the fact to simply tell you what it did say. And this has been, I can tell you from my experience on the Toronto District School Board, a recurring problem where we simply get a briefing after the fact on the budget and we say, well, wait a minute, you should have talked to us beforehand so we can give you our thoughts on what you should be doing. It's gotten a little better, but we've got a long way to go at that at the TDSB's SEAC, in my experience. Now, let me take the rest of my time to give you some very practical action tips. First action tip. I'm not going to number them because the numbers would run on and on. But the first one, it's really important for either your AAC or your SEAC to control and set your own agenda. I've gotten feedback that a number of them, the city staff in the case of AACs, or the school board staff in the case of CX, they set the agenda. The members of the committee come in, they're told, here's what your agenda is. That's what happened when I first joined this Special Education Advisory Committee of TDSB in 2015. And what I saw we got was a very long agenda with a bunch of things with 5 minutes on this and 2 minutes on that. And it was all busy work, but none of it, for the most part, or almost none of it, involved actually giving advice and recommendations. It was more a matter of them telling us what was going on. It's really important for you, your committee, led by your committee chair, to set your agenda. The staff can suggest topics if they want, but you should control your own agenda. In setting your agenda, I really strongly encourage you, don't try to do everything. You've got limited time. Set a few priority topics per meeting. If you meet for 2 hours, you can maybe deal with 4 or 5 topics in a way that gives you time to thoroughly discuss them and make some recommendations. If you have a long list of updates and reports and things, you'll have spent a lot of time talking, but not actually spend much time making recommendations and giving advice. You should be flexible in case there's some last minute priority crisis that hits the news the morning of your meeting. One day at TDSB, there was news that at the start of the school year, school busing was seriously messed up, and we had to basically put some of our other priorities aside and say, we need to get the school board to fix this, and now, and so on. How do you come up with these priorities? It's best if the chair of your committee canvasses the members, invites input on priorities by either email or at a meeting, and then you can divide up priorities over different meetings. Let me give you some tips on where, when, and how to hold meetings. First, I strongly encourage your committee meetings to be hybrid. They used to always be in person. Then came COVID. They went online. For some, continuing to hold them online is much easier because it saves travel time and is especially helpful in the winter. And that's an option. But if there's going to be any in-person aspect to it, it should at least be hybrid so that people don't have to face transportation barriers and the added time constraints. For example, at Special Education Advisory Committee, members are often or should often be parents of students with disabilities. They have a lot on their plates. And it's a lot easier to just sign on to a Zoom meeting than have to travel and park and so on and get caught in traffic. Um, the advantage of them being live streamed, pardon me, of being virtual or hybrid, is you can live stream them. And that's really a good practice I recommend, because then the media, the public, other people who are interested can follow these. A number of these committees are doing that now, but it should be a universal practice. Um, it is strongly recommended that these committees meet after work hours. Some do, and some don't. But the importance of holding them after work hours is, remember, the people who serve on these committees are volunteers. And lots of them have work, have jobs, and shouldn't be having to give up their holiday days, or work time to be able to take part. It's hard enough to get good people who want to donate their time to these committees. We're indebted to those who actually do volunteer to serve on these committees, but let's make it easier. If whichever way meetings are held, the municipality, in the case of AACs, and the school board, in the case of special education advisory committees, they have a duty to accommodate participants on these committees with disabilities. That may mean assistance with transportation if there's no accessible transit to get there, or it's hard to get to the meeting. It means ensuring that whatever platform they use for virtual meetings is accessible. Unfortunately, some municipalities keep using WebEx, even though it's frankly not good for accessibility. Zoom is much better. If there are people with hearing loss, it's important to provide real-time captioning and sign language where needed. And it's really important that documents be provided in accessible formats. Municipalities, school boards often provide information in PDF, either oblivious to or otherwise not responsive to the fact that PDF creates significant accessibility problems for people with vision loss. And therefore, if information is provided in PDF, it should also be provided in accessible Microsoft Word or other accessible formats. The other thing is, I strongly recommend that you urge the city or the school board to publicize the when and where of their meetings of the AAC or SEAC, because you want the public following what you're doing. You want the public knowing what you're doing. You want, whether they come in person or watch online. Part of your impact, or the effectiveness of your impact, is bolstered when others in the community see what you're doing and can put pressure on the elected politicians to support what you're doing. Now, next area I want to spend a couple of minutes on is use your time efficiently. How do you do that? Well, my strong suggestion from a lot of experience is this. Do not have long presentations that I call show and tell, where staff from the city or staff from the school board come in and spend 25, 30 minutes making a presentation, often sending you a PowerPoint in advance, which you can read, only to then come before the meeting, present the PowerPoint, and read the whole thing aloud again. What is a much more efficient use of your time, if there's going to be a report from city staff, is to say, look, could you please first send us your PowerPoint in advance, or send us a written report in advance, which we can, post online so the public can see it and read it, and so we can see it and read it, and then come to the meeting and give us just a 2, 3, 4, 5-minute synopsis of the high points. Assume we've read it, assume we can read and we know what we're reading, and digest it, and then have the rest of the time available for members of your AAC or your SEAC, your advisory committee, to actually do what they're there for, which is to give feedback, ask questions, to give advice, or even to formulate a motion if necessary. Now, you don't need to be rigid about this. Sometimes you may have a community group that wants to come in and they want to spend a longer time presenting, but then they can squeeze into 5 minutes. Unfortunately, some AACs and some SEACs use a fairly rigid rule that members of the public can only speak for 5 minutes, and they'll cut you off and then open it up to questions. Sometimes people need a bit more time. It's worth being flexible and non-rigid about it, but avoid the long presentations where everybody's just listening. Um, you're there. You're not the listening committee. You're the advisory committee. So you want to spend time getting advice. The other thing that's useful about people presenting reports in advance is that members of the committee can read the report in advance and fire questions off. I know on our TDSB SEAC, we see a report from the staff that we read a few days in advance. We can send an email into the staff in advance saying, by the way, I read that you said this in the report. Could you just, when you come to the meeting, let us know about X? And that helps everyone. So the staff don't get caught off guard at the meeting. They can look up the answer. They may, in fact, email it out in advance. So it saves everybody time. Now, let me turn to another area of tips I want to give you. There are times that staff from municipalities may give advice or directions to members of an advisory committee which are not correct. And it's important that you not have your action limited by this. Now, I've gotten feedback, the AODA Alliance has gotten feedback about a number of things. We weren't there when these things were said or might have been said, so I can't verify whether they were said in most cases. But let me put these as hypotheticals rather, and certainly not pointing at anybody in particular. Members of one accessibility advisory committee in one city said that the city staff told them, you are not advocates, you are just advisors, you should not engage in advocacy. Again, I don't know if they were actually told that, I'm just telling you what someone was said. But if that's ever told to you, my strong suggestion is do not feel in any way hampered by that. I don't know what the difference is between being an advisor and an advocate. Anybody on one of these committees is an advocate by definition. Otherwise, you wouldn't be on it. These are people who are advocating for improvements for people with disabilities. You are there to advocate. There's nothing wrong with advocating. I would not be in any way deterred by that kind of thing. I was actually at one SEAC meeting where a presenter that the TDSB brought in said that those of us on our SEAC who represent an organization relating to a particular disability, that we are not at that committee at the SEAC table to advocate specifically for the interests of that disability. I had no idea where they got that from. It's wrong. If you are representing, for example, an organization concerned with kids with autism, and you go to a special education advisory committee, of course you're going to be advocating and focusing on the needs of kids with autism. That's what you're there for. One member of an AAC I spoke to once felt that maybe they're not allowed to talk to the media about issues that are before them. That may not be something any staff had told them. I have no idea, but they were worried. Well, you can talk to the media anytime you want. You are governed by, as far as I'm concerned, the Charter of Rights guarantees in Section 2B the right to freedom of expression, and just joining in one of these committees does not stop you from speaking to the media if you want. Similarly, you should feel free to talk to any city staff you want. If you're on an AAC, you should feel free. And I'm not suggesting anybody ever said you couldn't. You should feel free if you're on a school board's SEAC to talk to anybody at the school board. You can talk to politicians between meetings. I actually had a weird situation where I was going to be potentially appearing before one of these advisory committees, and the chair said, I wrote the chair and said, hey, can we have a phone call to talk about this? And I was told, no, I can't really talk to you about it because you're going to be appearing before a committee. Well, there's no reason why that was the case. Those of us who are on these committees, we talk to all sorts of people all the time. There's no reason why you shouldn't. The final one, and this is just totally bizarre. I've heard, again, I can't vouch for whether this happened, but I've heard that in one case, an AAC took a position on an issue, and then they wanted to revisit it and possibly change their advice. And some city staff person said, sorry, that's out of order. You're not allowed to do that. As if once you've spoken, you can't speak again. That, of course, is completely, in my view, completely wrong. So you should feel free to speak as much as you want. The final thing I'd watch out for is when a municipality or a school board is presented with a problem and they say to you, well, why don't you guys, why doesn't your advisory committee write the province? Because it's the province that's to blame. Now, there are times the province is to blame, but, and you may well want to write the province, and there's nothing wrong with doing that. But on the other hand, it is really important to remember that you are there to advise the municipality or the school board. And you don't want to have your concerns deflected. Because even if part of the problem comes from the province, you can still turn to the municipality or the school board and say, fine, we realize that you may have some concerns with the province, but what are you going to do about solving this problem at your local level? Now, let me turn to another topic here. What do you do after you pass a motion? Is it all done? Like you pass a recommendation recommending some kind of reform. Does that mean you're done? Move on to something else. Well, you will want to move on to something else, but it doesn't mean you're done. There are several things you can do to help turn your motion into action, to try to. Again, no guarantees. The first thing is it is worthwhile communicating to staff that report to your AAC or that report to your SEAC that you want to report back on what follow-up there has been. Keep us posted on what's being done. And that is a perfectly reasonable request, and it's worth continuing to ask if you continue to hear nothing. You can, as a member of your advisory committee or your chair can, appear before a committee of the city council or the special school board to present the recommendation and to call for action. Often, the city or the school board will say, we want this, when an advisory committee passes a motion, it should be sent to one of our committees. Well, a concern I've had about that is, at one level it makes some sense, because they've got a lot of business and they route it through committees first. But it can't die at the committee. You have, in my view, if you're on a SEAC, my view is you make a recommendation, you're making a recommendation to the entire school board. And the entire school board should consider it. If they want to send it to a committee first, that's fine, as long as it gets to the whole school board. That the committee can't essentially kill it from moving on. Now, unfortunately, the way some municipalities or school boards conduct their business, I am worried that the recommendation or the motion may never get for a full debate at the full school board or at the full city council. And if that's the case, I think I would encourage you to advocate for the mayor or the chair of the school board to bring the motion up before a discussion by the whole city council or the whole school board, as the case may be. A second thing you can do, or a third thing you can do, one is asking staff for an updates. One is formally presenting your motion to a committee of city council or of the school board or of the whole council or the whole board. Another thing you can do is try to coordinate with your advisory committee members to get to the elected politicians and advocate to them one at a time. That may be by phone, by meeting, by social media, by tweet, whatever works. Another thing is on your special education advisory committee or your municipal accessibility advisory committee, you will invariably have elected politicians. There are typically city councilors on them, or in the case of SEACs, school trustees. Work with them to help advocate to the whole elected body to consider your recommendation. They're your most obvious natural allies. Use social media, use regular media. If a motion is passed, a recommendation is made, there's no action on it, go to your local media and say, hey, we passed this, we can't get any action. Why don't you contact the mayor's office or the office of the director of education and say, hey, what do you do? And get the reporter to ask, what are they doing about it? Sometimes that will get you more action. Let me turn to yet another tip. There are times when you will benefit from actively inviting some outside expert group to come in and advise your committee of an issue that requires action. Several years ago, when I was chair of the Toronto District School Board's Special Education Advisory Committee, I contacted the Arch Disability Law Center, a fabulous legal aid clinic in Toronto that serves the legal needs of people with disabilities. I invited them to come in and do a briefing of whatever they wanted on education. And their executive director, Robert Latanzio, excellent lawyer, came in and he raised an important issue that we really hadn't focused on: the power of school principals to refuse to admit a person to school, including a student, on the ground that they think that their presence may be detrimental to the physical or mental well-being of students there. And he explained that this power to exclude students from school has been used systemically against students with certain disabilities. He raised a serious concern. We then asked the school board to bring in a staff report on this at a subsequent meeting after the board had time to prepare. They had an official come in, explain what the board's approach was, explain that the board's approach was actually needed to be significantly reformed, that they didn't have a policy on this. And in a series of follow-up meetings, the school board brought forward proposed new policy in this area. We gave feedback on it, they came back with revisions, and ultimately they passed a policy at the school board, which was a significant improvement over what they had been doing in the past. And this all came from inviting an outside contributor to speak to us and to raise an issue. Another action tip I'm going to offer you is to get your Accessibility Advisory Committee or Special Education Advisory Committee to hold a Barrier Busters Town Hall. You can do this virtually on Zoom. You get the school board or the city to organize it. You invite members of the public to come and present what kinds of barriers they face and recommendations for reform or action that they need. And this provides an opportunity for your committee to hear from lots of other people. Just because the municipality or the school board appoints a dozen or 20 or however members doesn't mean that your experience is the experience of absolutely everybody with disabilities in the community. This gives you a chance to open it up, and that can be really helpful. And with Zoom, you can do breakout groups, collect ideas, collect input, and of course, it's helpful if the city or the school board can publicize these kinds of events in advance, ensure that they have sign language and captioning for people with hearing-related disabilities and so on. Let me conclude with just a few more ideas. Generally, what do you do if you get a response from the school board or from the city just, oh, we can't afford that? That's often a knee-jerk answer that you get. And when you watch the video, or if you watch the video that I'll give you the link to associated with this presentation on my introduction to the duty to accommodate people with disabilities, you'll learn that they can't just say, oh, that costs and we can't afford it. They have a burden, a duty to accommodate, unless they can show that the cost of doing so is so prohibitive that it would cause an undue hardship. And even then, that doesn't mean they can just say, we're not going to spend anything. And often, when people say something costs too much, they may well have overestimated what the cost is. So don't consider that like a showstopper. If you are on a special education advisory committee, there's a resource I want to point you to and a video that I'll link to this video that will be very helpful. I mentioned in my introduction that I served on the Kindergarten to Grade 12 Standards Development Committee. We rendered a report to the government of Ontario in January of 2022, which provides a detailed review of the barriers facing students with disabilities and detailed recommendations. Now, at the time that I'm recording this in June of 2023, the Ontario government has not taken action to implement any of those recommendations. But nothing stops a SEAC at a school board from taking that report, reading it, and making recommendations on what the school board should be doing. I'll provide a link to a video where I summarize that report. I strongly encourage you to use it and try to pluck from it action areas that you think are worthy of immediate action. What do you do when you are facing a situation where you think there's a problem, but you just don't know what the situation is, whether it's at the municipality or at the school board? Well, ask for information. I adverted to this earlier, but a written request to the city staff or the school board saying, can you let us know what your policy is on this? Or can you let us know what statistics you have on this? Typically, staff will be very helpful. If they don't, you have the opportunity of spending $5 and filing a Freedom of Information request, because our Freedom of Information legislation applies not only to the provincial government, but to other bodies like the school board and municipalities. Let me give just a few final recommendations, of which there are tons more that I could. If you are on a municipal AAC, your municipality passes bylaws. These are laws. They should themselves not create any barriers. You should consider passing a motion that calls on the municipality to undertake a project to review its municipal bylaws for accessibility barriers. Now, how do they know what accessibility barriers there are? Well, I co-wrote a Law Journal article that talks about how to review legislation for accessibility barriers. And if you write me at aodafeedback@gmail.com, aodafeedback@gmail.com, I'll send you that Law Journal article. It's a complete roadmap on how to do one of these reviews. Let me conclude by offering you just a couple of thoughts. It's very easy when you're on a municipal AAC or on a school board's SEAC to get so tied up with all the details that you get so busy, and then at the end of the meeting you go, or at the end of the year you go, we held a lot of meetings, but what did we accomplish? It's really helpful to start the year by saying, as a group, here are 3 or 4 or 5 areas where we want to make sure that we take action, and at least try to get reforms. And at the end of the year, to be able to look back and say, well, we made progress. We picked 4 or 5, maybe we got progress on 2 or 3, but it's better than had we not done it at all. You're best able to do that if you follow the tip I gave you early on to try to zero in on a few priorities rather than get divided up among millions of small agenda items that will keep you busy but not achieve change. I recommend that you encourage the province to do something it hasn't done in years, which is to hold a conference for accessibility advisory committees of municipalities and special education advisory committees. In fact, I don't know if they've ever done the two together. They've had a conference for AACs back in 2009, one for SEACs, I think around 2015. But with Zoom, we could easily do that now with no travel costs involved, but an opportunity to learn from each other and share tips. And it's a low-cost sort of thing that is quite easy to do. I also encourage you to reach out to the AODA Alliance. We can't give legal advice to anybody. We can't we could try to come if you'd like us to come and do a deputation. We can do it virtually to offer you some practical tips beyond what's on this video. I encourage you to get other members of your SEAC and your AAC to watch this video, because we hope that this will be training that will be beneficial to everybody. Let us know what works. Write us at aodafeedback@gmail.com and let us know what works. Let us know if any of these tips worked or some of them didn't work. Maybe we'll do a sequel. Do check out the videos that I'm going to provide links to on an introduction to the AODA, an introduction to the K-12 Standards Development Committee report on an introduction to the duty to accommodate people with disabilities, and in the case of CX, tips for parents of students with disabilities on how to advocate for your child at school. And finally, really encourage you to sign up to get AODA Alliance updates. Go to our website, www.aodaalliance.org, www.aodaalliance.org. And when you get there, just go to the sign up link, paste in your email address, and you'll get action tips and updates. And we'll keep you posted on what's going on. Follow us on Twitter at AODA Alliance and on Facebook, the Accessibility for Ontarians with Disabilities Act Alliance. I hope you found this video helpful. Again, thank you for taking the time to serve on an accessibility advisory committee or on a special education advisory committee. And good luck being a barrier buster. We all need your help and support, and I hope these tips will help you make the best of it. Take care.